The International Criminal Court is now in session.
Good afternoon, everyone, and welcome to this session of the pre-trial chamber of the International Criminal Court in the case of the prosecutor and Mr. Gravus. My name is Matthew Cross, and I will be presiding over this hearing today, and I'm joined by my fellow judges who will now also introduce themselves. Thank you.
Hello, I'm Roger Clark. I'm one of the other two judges.
I'm Gleb Bogush, and I will be also judging this hearing. Thank you.
Thank you very much. And now can we hear the appearances from the prosecution, please, and also indicate how you'd like to use your time. Thank you.
Mr. President, Your Honours, and may it please the Court. My name is Zuzanna Ganczewska, and together with my co-counsel Kaja Stelmaszewska, I will be pleading for the prosecution. I will be speaking for the first half of the pleading, and my co-counsel will be speaking for the remaining half. We reserve 5 minutes for the rebuttal.
Thank you very much. And now the same for your colleagues from the defence.
Mr. President, Your Honours, my name is Büşra Altuntaş, and it's an honor to appear before the, on behalf of the defense. We will reserve the maximum of the available time for the rebuttal.
Thank you very much. And for your main submissions, are you planning on dividing those between the two counsel? And if so, how do you plan to do that?
I'm sorry to interrupt, but one of our co-counsels, our third speaker, is still in waiting room. Can you let him into it? Thank you. Sorry to interrupt again.
That's quite all right. Thank you.
Excuse me, what's his name here on Zoom?
Yes, his name is number 113, Hemet Vengo.
Well, he isn't shown to me as being in the waiting room. Maybe he's in the wrong room, I don't know.
Maybe his name would be different because he's using a different laptop now.
Mm-hmm.
So if you can let him into it, he can change his name.
If it's
yes, it is P2 Karsu.
Ah, okay. So he just needs to come back to the waiting room since he's now left it.
No, you have let him in. He's in the meeting now.
Ah, perfect. Then it was my colleague. Thank you.
Thank you.
Thank you very much. So if I can confirm, we now have all of the defence counsel present. Yes. And then just to clarify, in your primary submissions, how would you like to divide the speaking time in your 25 minutes?
I will speak for 8 minutes on the issue of jurisdiction. My co-counsel, Ms. Avcı, will cover the issue of admissibility for 7 minutes, and Mr. Hemet Vengo will cover the issue of superior responsibility for 10 minutes.
Thank you very much. So if we're now all ready, can I...
May I briefly interrupt? I see that the team, Mr. Karsu, has the wrong... It's indicated as prosecution. Okay, thank you. Just to be correct. Thank you.
Thank you very much. So if we're all ready, then prosecution counsel, would you like to begin?
Thank you, Your Honour. Mr. President, Your Honours, and may it please the Court. Present case concerns genocide carried out by killing and deliberately inflicting conditions of life calculated to bring physical destruction of Castilians, an ethnic group residing predominantly in Castilla, a region in the country of Hanatun. Mr. Gravus, against whom these proceedings are being conducted, has been a president and commander-in-chief.
Counsel, could you slow down a little, please? Slow down a little, please.
Not so fast. Your Honour.
Thank you.
Bear in mind, submitted by the defense, the prosecution will submit 3 claims. Firstly, that the case against Mr. Gravus is admissible before the court. Secondly, that it falls within the jurisdiction of the court. And thirdly, that there are reasonable grounds to believe that Mr. Gravus is criminally responsible under Article 28. I will be speaking on the first claim and begin with the second claim. The second claim and speak on the third claim. The complementarity requirement, as the state is not investigating the case. The prosecution acknowledges that a military court was in December 2021. Yet, as the appeals chamber stated in the Ruto 2011 judgment, mere some investigation is ongoing is not enough to determine inadmissibility. Moreover, the pretrial chamber stated in the Gbagbo decision that the termination of an ongoing investigation must prove that firstly, it concerns the same conduct as alleged before the court, and secondly, the state has been taking tangible, concrete, and progressive steps towards establishing perpetrators' criminal responsibility. The PTC stated as well that initiation of and detention of a suspect cannot be classified as such. In this context, it must be underlined that the investigation in question refers only to very vaguely defined crimes committed in the conflict regions, and the state actions were limited precisely to the ones that were considered insufficient in Gbagbo. However, should this not satisfy the court, the prosecution submits that the state is unwilling to genuinely investigate and subsequently prosecute Mr. Gravus for genocide, as required by Article 17(1)(a) of the Rome Statute, as the proceedings are aimed at shielding the perpetrator from responsibility and are not being conducted impartially. It has been underlined in the jurisprudence of the European Court of Human Rights in cases concerning alleged unlawful deprivation of life by state agents that it is necessary for persons responsible for carrying out the investigation to be independent from those implicated in the events, which means both institutional as well as practical independence. In the present case, the prosecution observes that it is a military court that conducts the investigation and possible subsequent prosecution of a former military and security forces commander-in-chief. Therefore, Mr. Gravus is being investigated by persons who most probably had been under his command before, and who, given the scale of the events, may be...
Counsel, may you clarify your point? So your submission is based solely on the fact that it's a military court, because I think it's a practice of many states that the cases like that are tried by military justice institutions. So that happens everywhere. So, or you have some other arguments regarding independence of the court.
I would like to point out that we base our submission that this is a military court, but also Mr. Gravus has been a commander-in-chief and president at the time, and given the scale of the events, persons who may be the part of the military court may be complicit in crimes and were under command of Mr. Gravus before. Therefore, and also we cannot forget that it may also be evidenced by the fact that senior military officials are already recommending the release of the accused. And even though they are not a part of the court, like to be irrelevant to those conducting the investigation and eventual prosecution. What is more, the OTP believes that launching the investigation only after the ICC took action, despite long-standing knowledge of the crime and insufficient step within the investigation, attests to a lack of willingness to hold the alleged perpetrator accountable. It should also be noted that the proceedings before the military court began 3 months after the arrest warrant issued by the incoming closing of the investigation. The state did not provide evidence of its own action. Therefore, the prosecution...
Counsel, may you assist me with the evidential test for regarding independence in this particular aspect, independence of the judiciary? So what kind of standard should the court use to consider this issue? So what kind of tests? So reasonable grounds to believe, substantive grounds to believe. So how we should assess this issue? Because you provide us with certain speculation that military justice is not independent and some other information. So what is your suggestion for us? What is the evidential standard under the particular stage of proceedings?
I think we've lost prosecution counsel.
Yes, I'm sorry, but we can exchange it later. Yes, it seems like she already has the connection. So just a second, we are very sorry.
Not at all. Thank you very much.
Don't you hear me? I have lost the.
We can hear you, but not very well. We heard you for a moment, and then we seem to have lost you again.
Okay, so I'm sorry for the interruption. And regarding your honest question, and we believe that as we are currently at the pretrial chamber, and this is a still pretrial phase of the proceedings, the current standard of proof should be the reasonable grounds to believe. And we should also note that the prosecution is aware that the ICC is not a human rights court, and that yet this lack of impartiality of the military court is indicative of the state's unwillingness to genuinely investigate and subsequently prosecute.
Thank you. Thank you very much. Thank you very much.
Thank you, Your Honor. And therefore, the prosecution finds that the investigation has been opened not as a transitional justice mechanism, but in an attempt to shield Mr. Gravis from genuine investigation and prosecution at the ICC. As the complementarity criteria has been fulfilled, the prosecution will assess the gravity of the case now. It must be understood that this criteria, as the appeals chamber stated in the Al-Hassan 2020 judgment, allows for exclusion of cases that are only of marginal gravity and not for the selection of all. Nevertheless, the prosecution states that the case of Mr. Gravis be considered as grave from both quantitative and qualitative viewpoint. From the quantitative viewpoint, the key criteria is the number of victims, consisting in the present case of at least 286 Castilian victims of genocide by killing, an unknown number of deaths, and an even larger number of those affected due to the infliction of conditions of life calculated to bring physical destruction. Determining qualitative gravity, and considering the decision in Abu Ghara, the number of victims should not be the sole gravity criteria, the prosecution observes that in the present case, the accused, as president and commander-in-chief of the security and armed forces, has the highest genocide responsible for were killed, forces, raped to work, among them women and girls. The question had been committed as a part of the discriminatory campaign against Castilians, of which numerous examples present in the case facts, of concern for the international community as a whole. Therefore, the case of Mr. Gravis meets both the complementarity and gravity requirements, and as such should be considered admissible. Moving on to the jurisdiction of the court to assess the case of Mr. Gravis, the prosecution claims that the present case fulfills all of the jurisdictional parameters. For the territorial or personal parameter, the prosecution reminds that the court's jurisdiction has been activated by the UN Security Council referral pursuant to Article 13b of the Rome Statute. When the ICC's jurisdiction over a given situation is activated by means of a UNSC referral, the court may exercise such jurisdiction even if crimes in question have neither been committed by nationals nor on the territory of a state party. The ratione temporis condition is undoubtedly satisfied as well as crimes in Hanatun were committed after 1st of March 2019. The case against Mr. Gravis meets the subject matter criteria too, as it concerns the crime of genocide. I will begin with the assessment of the acts committed, and my co-counsel will move on with the assessment of the character of the group.
Counsel, just before you move on, a question. If the court has jurisdiction over this situation by virtue of a UN Security Council referral, what is the source of law that we should be applying when we're looking at the elements of genocide?
Your Honor, according to Article 13b, if the court's jurisdiction in a case has been activated by the UN Security Council referral, the the case should be assessed basing on the Rome Statute, as the resolution will refer the case to be accordingly with the Rome Statute.
Thank you.
Your Honors, the case against, I will begin with the, regarding the subject matter criteria, I will begin with the assessment of the acts committed, and my co-counsel will move on with the assessment of the character of the group and the perpetrator's intent. The prosecution submits that the genocides against Castilians have been committed by firstly killing and secondly deliberately inflicting conditions of life calculated to bring physical destruction. Relating to the first act, according to international human rights defenders, in the night on 15th of July 2019, the National Directorate of Security of Hanatun, in coordination with the Special Presidential Guards, entered multiple houses to arrest Castilians, allegedly for political affiliations. 200 Castilian men were shot dead when they resisted arrest. Followingly, the IHRD reported that 86 male companions were shot in the head when families trying to flee were blocked at the border by checkpoint police. Regarding the second act, Article 6C refers to methods by which the perpetrator ultimately seeks physical destruction of the victims, as explained by the ICTR in Akayesu. According to the elements of crimes, it may include deliberate deprivation of resources indispensable for survival, such as food, and additionally, according to the ad hoc tribunals, it may also include rape, the creation of circumstances that would lead to a slow death, and excessive work. In this respect, the prosecution observes that, firstly, in July and August, the police department forced all local businesses in Luz and Sicily to close and warned them not to reopen. At the same time, all routes to Castilla were blocked. These acts resulted in severe famine, and social media images from the period showed dead bodies of women and children on the streets. Thereby, it must be acknowledged that Castilians were deprived of resources indispensable for survival. Secondly, following the blockade, 150 female Castilians, among them girls, were arrested at the border by checkpoint police. They were subsequently taken to different stations where they were forced to work and provide sexual services under the threat they would be killed if they refused to do so. In such case, it must be understood that female Castilians were raped and forced to work, which, as highlighted in the ICTR Kaishema judgment, may constitute actus reus for genocide. That, yes, Your Honor.
Counsel, may I ask you another question? Could you please comment on the contextual element of genocide provided by the elements of crimes? So I quote, the conduct took place in the context of manifest pattern or similar conduct directed the group, or the conduct could itself affect such destruction. So provided that you refer to just a few episodes, can you comment on that requirement?
Your Honor, I seem to have lost the connection for a second. Can you repeat the question? I'm sorry.
I'm asking you to address the elements of crimes, the contextual element of genocide provided by the elements of crimes of this court. So I quote, the conduct took place in the context of manifest pattern or similar conduct directed against that group, or the conduct could itself affect such destruction of the protected group. I'm asking you, you referred just to a few episodes with the relatively small number of victims. So that's why I'm asking about this element.
Yeah, Honor. I would like to answer your question on two grounds. Firstly, for the genocide to state that there was a genocide, it doesn't require a particular number of victims. As the court stated in the case against al-Bashir, it is not necessary. It is just it is enough for a court to it would be enough for a genocidal intent to manifest in a single situation. Therefore, it doesn't require for a particular number of cases. What is more, those acts were committed as a part of a discriminatory campaign. This discriminatory campaign, as my co-counsel will elaborate on later, began when Mr. Gravus took place as the president, and since 2015 there were some discriminatory incidents, and then it led to the genocide that we are currently assessing. And we should also note that there were not just some single incidents, but they were committed as a part of a particular pattern.
Okay, thank you.
Thank you, Your Honor. Bearing that in mind, the prosecution observes that the acts allegedly committed fall under the definition of genocide, constituting the first part of the ratione materia. As the circumstances characterized in the pleading imply, these acts were deliberately conducted against Castilians, on which my co-counsel will elaborate now.
Thank you, Counsel. Mr. President, Your Honors, may it please the Court. I would like to start with explaining why the Castilians must be considered a group protected under GRS, precisely an ethnical group. Then I will argue that there was an intent to destroy this group in whole. First, there are obviously no precise definitions of the groups protected by DRS. However, the international criminal tribunals have established that determination of the groups should be made on a case-by-case basis by reference to both subjective and objective criteria. In a Cayesu trial judgment, the ICTR established that an ethnical group is a group whose members share a common language or culture. And since in the present case, Castilians represent a unique culture, speak a distinct language, Otati, and profess a distinct religion, they must be considered an ethnical group. It is submitted that in the case at hand, the Castilians were indeed targeted because of their ethnicity. As there is no evidence that the CNF members committed any act of terrorism, fighting terrorism was only a pretext. The OTP would like to draw the court's attention especially to the following facts. First, from paragraph 12 of the case, it follows that during the searches, 200 Castilian men, including 2 CNF members, were shot dead. Hence, 198 Castilian men who were killed were not CNF members. Next, paragraph 13 of the case, where it is stated that the NDS were actually pressuring Mr. X to say that he supported CNF. But once they found out that he was of Hannu ethnicity, they released him. Moreover, Castilian girls aged 13 were forced to cook and provide sexual services. It is not acceptable to perceive forced labor and sexual violence against children as a method of fighting terrorism. Moreover, the perpetrators of the crimes must have been aware that the blockade of Castilla would have tragic consequences to the whole nation, ethnic group of Castilians, not only the alleged terrorists. Moving on to my second submission, the OTP states that in the case at hand, there was a dolus specialis to destroy Castilians. As it was held, for example, in Mladic or Karadzic trial judgments, in the absence of direct evidence, specific intent may be inferred from the surrounding facts and circumstances of the case, which may include, first, the general context, second, the scale of the atrocities, third, the repetition of destructive and discriminatory acts, or fourth, the existence of a plan or policy. Now I would like to address some...
Could you clarify one point? Who has, in your opinion, the genocidal intent or the special intent to destroy a group? The accused, in this case, Mr. Graves, or the perpetrators? Or both groups, or him and the perpetrators also possess genocidal intent? It's important, I think, in terms of the responsibility.
Thank you, Your Honor. I am referring to the intent which was shared by both the direct perpetrators and by their superior, Mr. Graves. Of course, over the course of years, a very different understanding of the superior's intent were presented. For example, the ICTY in the Brydzianin case held that the superior the superior responsibility does not require proof of intent on the side of the superior. However, for example, in Akayesu, the ICTR stated that the negligence must be so serious that it is tantamount to malicious intent. First of all, there is a still ongoing debate on for what exactly is the superior responsible. For example, the ICC in Bemba stated that it is a sui generis responsibility. Hence, due to
Counsel, my question referred to the particular to our case, not to the theoretical debate. So please be specific in terms of the facts, because I think we don't have time to.
Yes, I'm sorry. I just wanted to state that superior responsibility is a omission kind of liability, and hence omission can be intentional. Hence, there is no conflict between genocidal intent and mens rea in Article 28. As my co-counsel already explained, there was a discriminatory politics against Castilians in Hanatun. Moreover, there's also hate speech against them, as Mr. Gravus openly vowed to eradicate the Castilian cancer from the map of the country and called Castilians lying rats. It should be stated that according to the Humana judgment, this kind of speaking creates a lesser status in the eyes of others who perceive and treat them as less human. And that was also seen in the course of other genocides or human massive violations. For example, Nazi propaganda called Jews rats, just as Mr. Gravus was calling Castilians. Moreover, we had obviously the existence of a penal policy, as we see in paragraph 11 of the case, and the repetition of destructive and discriminatory acts on which my co-counsel has already elaborated. Your Honors, genocidal intent may manifest itself in two forms, to destroy a group in whole or to destroy a group in part. The OTP submits that in the case at hand, there was an intent to destroy Castilians in whole. And it should be emphasized that the actions carried out by the authorities were aimed at both men and women, children, and even pregnant women. Hence, the OTP concludes that there was a dolus specialis in this case and the crime of genocide was committed. Now, I would like to move on to the next issue, which is Mr. Gravus' criminal responsibility under Article 28. First, according to Bemba trial judgment, the term military commander refers to a person who is formally or legally appointed to carry the military command function. As Mr. Gravus served as the commander-in-chief of the armed forces and security apparatuses, he should be considered a military commander. The OTP submits that Mr. Gravus had effective control and command over the perpetrators of the crimes. I would now quote some factors from Bemba judgment, which may indicate the effective control. First, the official position of the suspect, here evident in Mr. Gravus' case, basing on paragraph 7 of the facts. Second, his power to issue or give orders, here fulfilled basing on paragraph 11. Third, the capacity to ensure compliance with these orders, in the case following from paragraph 12 and exhibit 1. Your Honors, Mr. Gravus had effective control over all of the services in Hanatun, as he was the commander-in-chief and the president. It is clear from the case facts, both Mr. Jory and Mr. Bryan stated that they were following Mr. Gravus' orders. Moving on to the mens rea element, namely knew or should have known standard, it is submitted that Mr. Gravus knew that his subordinates were committing crimes, which could have been recognized as genocide. In the light of the general context of the case, taking into account the scale of the crimes, the duration, all evidence gathered, and his position as a president commander-in-chief, there is no possibility that Mr. Gravus did not have cognizance of the crimes. Nevertheless, should that not satisfy the Honorable Court, he nevertheless should have known about the crimes. And this standard in Article 28 requires more of an active duty on the part of the superior to secure knowledge. Meanwhile, Exhibit 1 shows that Mr. Gravus might not have taken the necessary measures to secure knowledge, as his questions were rather vague. Mr. Gravus did nothing. He did not take any measures to prevent or to repress or to submit the commission of crimes. Even when the international community strongly condemned the situation in Castilla and urged the government to take humanitarian actions to feed the people and stop the extermination of Castilians, Mr. Gravus replied only by blaming the leaders of Castilla for the harsh economic situation in the country. Your Honors, to conclude, the prosecution invites the court to find that the case is admissible, that there are reasonable grounds to believe that the case falls within the jurisdiction of the court, and that there are reasonable grounds to believe that Mr. Gravus is criminally responsible under Article 28A of the statute. Thank you, and may it please the court.
Thank you very much, counsel, for the prosecution. And now, bear in mind the time, we'll move to submissions from the defense. Thank you.
Mr. President, Your Honors, may it please the court. My name is Bishra Altuntash, and it's an honor to appear before the court on behalf of the defense. Mr. President, Your Honors, the accusations of the crime of genocide is not something to be done lightly. This crime is not only the manifestation of absolute evil, but it is also one of the cornerstones of this court's jurisdiction. Subject matter jurisdiction of this court depends all elements of the crime of genocide being demonstrated by the OTP on reasonable grounds. The OTP failed to demonstrate anything about the contextual element of the crime of genocide. To answer Judge Bogush's question to the OTP, the contextual element is the existence of a manifest pattern of similar conduct, and elements of crimes which the court applies in the first place as per as 21 of the Rome Statute requires such an element. Therefore, the chamber must decline jurisdiction. Now, I will turn to our arguments about the elements that OTP has mentioned. And
Counsel, just before you do, the same question to you that I posed to the prosecution counsel. Do you agree that the statute is the correct source of law for the elements of genocide, given how the Security Council has referred this situation to the court?
Yes, Mr. President, and your honors.
Thank you.
And now I will turn to our arguments about the elements that OTP has mentioned. And therefore, the primary submission of the defense is that this court lacks subject matter jurisdiction. And we have two arguments in support of this position. First, Castrians are not a protected group within the scope of Article 6. And second, neither NST and SBG forces nor Mr. Gravus did not have specific intent. And without a protected group or specific intent, there is no crime of genocide and no crime falling under the jurisdiction of this court under Article 5 of this Rome Statute. The OTP argued that Castrians are an ethnic group present in paragraph 4 of the fact sheet. However, that very paragraph, as well as a clarification number 1, noted that Castrians not only refer to an ethnic group, but also more generally to people living in Castria. Therefore, the term Castrian, the victims of the alleged genocide, refers to the general population of Castria, which includes Castrians as an ethnic group, but also other religious and ethnic groups and people who reside in Castria. Therefore, it does not refer to a distinct protected group under Article 6. And this, in a sense, puts a doubt on the identity of the targeted group of the alleged genocide, whether people of Castrian ethnic group or the general population of Castria. In any events, pursuant to genocide trial judgment, there is no genocide if the entire population is attacked, unless all elements of the general population can be defined as protected group under Article 6, and for which the OTP bears the burden of proof. And OTP invokes several conducts as material evidence of the crime of genocide. However, regarding 200 killings of people, even if we deem IHRD reports as credible, which will be challenged by my co-counsel, Mr. Hamed Mengo, these killings would hardly demonstrate a concrete and real threat in a country with a population of 43 million. And moreover, these killings in question only took place during the search and arrest of terrorists, which pose a threat against national security and the public order of Anatun, not in the rest of the campaign. And also, arrest is not one of the acts enumerated under Article 6. And similarly, the blockade was also carrying security purposes and was not specifically meant for the physical destruction of Castrians. And this blockade was all over the province of Castria. And in this case, and regarding clarification number 1, how can we say this blockade was targeting specifically Castrians as an ethnic group, while also other groups and people also reside in this area? And the fair mind cannot be.
Counsel, may I stop you here? You're referring to the evidence presented by the prosecution. So we among this evidence, we don't see any piece of evidence that pointed to targeting people other than Castilians, ethnic Castilians. Moreover, we have also evidence that also the prosecutor insisted on of the use of derogatory language and discriminatory rhetoric, violent rhetoric from the of the accused. So can you comment on this evidence?
Your Honors, regarding the statements such as Castrian cancer, genocidal intent or these acts must differ from the personal motives. So these statements such as Castrian cancer do not amount to establish intent or material element, but only the personal motive, and which states perpetrators not state of mind while the crime is committed, but the background only. And they do not show a concrete and real threat, but latent and hypothetical. May I proceed?
I would appreciate if you also say something about the choice of victims, actually. So we have the only episodes that targeted ethnic Castilians. So we simply don't have any other indications that that point to that it was not ethnic Castilians who have been targeted.
Pursuant to Jelicic trial judgment, as I mentioned earlier, the whole population of Castria can be accepted as attacked if the whole elements of the population can be described as protected group under Article 6, and for which the OTP bears the burden of proof.
Okay, thank you.
And this brings me to our second challenge concerning the subject matter jurisdiction of the court, namely the lack of specific intent to commit genocide. The OTP have relied on the specific intent of Mr. Gravos, while also invoking his responsibility as superior under Article 28, which is lawfully incorrect. According to jurisprudence of Appeals Chamber decision on Kristich case, it is noted that principal perpetrators, independent from their ranking and status, they must have specific intent to destroy the group or part of it. And therefore, it's not only Mr. Gravos, but also NDS and SPG forces specific intent, for which OTP bears the burden of proof. And OTP invoked knowledge-based approach by stating that NDS and SPG forces are aware of Mr. Gravos' intent. However, this knowledge-based approach does not compete with the reasoning of the Genocide Convention and rejected by the case law. And regarding Mr. Gravos' specific intent that OTP has mentioned, the anti-terrorism campaign's sole purpose was defeating CNF terrorists, and mentioning Castrian supporters was carrying the purpose of preventing CNF terrorists from hiding among or getting support from the local population of Castria. And the statements such as Castrian cancer or Panhono ideology that they were stated do not constitute a reasonable inference to establish the specific intent, since these statements are not accepted, can be accepted only as incitement, as it was stated out in International Criminal Tribunal for former Rwanda's trial chamber decision on Nahimana case. And we pray this court holds and finds that it does not have jurisdiction over this matter. Now I yield my floor to my co-counsel, Ms. Avcı. Thank you.
Mr. President, Your Honors, may it please the court. My name is Sema Avcı. As noted by my co-counsel, I will plead on the admissibility of the case under Article 17 of the Rome Statute. Article 17 addresses an admissibility test which consists of two steps in an unspecified order: complementarity criteria and gravity threshold. Your Honors, we concede the gravity of the case. Among other things, as the situation is referred by the United Nations Security Council. We recognize the atrocity of the incidents, and there is no justification when it comes to human dignity and fundamental human rights. However, the case is still inadmissible because the second component of the admissibility test, which is complementarity criteria, isn't met. According to complementarity criteria, the court's jurisdiction must be secondary. Republic of Anatun has jurisdiction over the case since the incidents occurred in its territory. Admissibility is determined based on the factual situation. Therefore, the time we have submit our admissibility challenge must be regarded by this court when determining the complementarity. When we have made our admissibility challenge, the investigation regarding the case had already begun in Anatun. We are aware that mere preparedness isn't enough, and Republic of Anatun must have taken concrete investigative steps.
Counsel, I have a question, if I may. Who has the burden of proof on the complementarity issue, Article 7? The prosecution or the defense?
Your Honor's defense has the burden of proof, since we challenge it.
Would you say that again?
Defense has the burden of proof since we challenge it.
Why are you conceding that? Is there case law in the appellate chamber to that effect?
Your Honor, since we made the challenge on admissibility, that's why we have the burden of proof as defense.
What about Article 67(1)(I), which says that the defense has the right not to have imposed on him or her any reversal of the burden of proof or any onus of rebuttal. Does that not support placing the burden of proof on the prosecution rather than the defense?
Your Honors, as a general rule, you are right. The prosecution has burden of proof. But since defense challenges the admissibility in this case, we have the burden of proof.
Thank you, counsel.
Thank you. Mr. Bogush has been placed under arrest in prison in N20. A military court has been established to investigate this matter. And it is planned to complete its investigation in August 2022. These clearly reveal that N20 has taken concrete and progressive steps, and it is in considerable effort to bring the case to justice. The investigation of the military court focused on the conduct of Mr. Bogush in conflict regions, including Castilla, from the year 2015, which means the investigation of the military court is concerned with the same person and same conduct in the case before the court. And to hear the case before the court results in a conflict of jurisdictions contrary to the principle of complementarity. We respectfully urge this pre-trial chamber to take a purposeful approach to interpret the case by applying the substantially the same conduct test as articulated in the judgment on appeal of the Republic of Kenya. Your Honors, N20 is willing to investigate. First, the investigation is not intended to shield Mr. Bogush from criminal responsibility. We understand the concerns regarding high-ranking military officers' recommendation of Mr. Bogush's release. However, we would like to remind the clarification number 3, which clearly reveals that these officers have no connection with the military court. Besides, despite this recommendation, Mr. Bogush was remained under arrest. This shows that these military officers have no effect on the military court. Secondly, there is no unjustified delay in the investigation. This is a complex case, since the new government has taken power from a destabilized situation. Despite that, the military court is established with a particular time limit. This shows N20's genuine intent for justice to be served in time. Indeed, ongoing investigation in N20 is genuine. Contrary to what OTP has argued, the establishment of the military court after 3 months after the arrest warrant of the court doesn't reveal that N20 is ongoing. The coup was held only 2 days before the arrest warrant of the court. It is illogical to expect from the new government to start the investigation in 2 days before stabilizing the situation in the country. Indeed, if it did, it would be not genuine. Military court was established only 3 months after the coup. Considering the turbulent situation of the country before the coup, this reveals that the new government has established the court right after taking the situation under control. Ongoing investigation in N20 is also impartial. There is no indication that shows right to a fair trial of Mr. Bogush as violated. According to United Nations Human Rights Committee's General Comment number 32 on the right to equality before courts and tribunals and to a fair trial, there is no violation of the right to...
Counsel, it seems that the position of the prosecution is that the proceedings have been designed to shield Mr. Bogush from responsibility. So it was a sham proceedings, actually. So can you comment on that?
Of course, Your Honors. They stated that since this is a military court, it is intended to shield Mr. Bogush from criminal responsibility. But again, according to United Nations Human Rights Committee's General Comment number 32 on the right to equality before courts and tribunals and to a fair trial, there is no violation of the right to a fair trial where military tribunals have exercised jurisdiction over individuals who are military personnel or, where appropriate, in the case of serious crimes under international law. Mr. Bogush is a military officer. He is alleged to have committed serious crimes under international law amounting to genocide. That shows the jurisdiction of the military court to investigate. Besides, according to a decision on the admissibility of the case against Saif al-Islam Gaddafi, there should be obvious and explicit deficiencies in investigation that show the intent to shield the alleged person from criminal responsibility, which is not the case which is not fulfilled in our case, and there is no obvious deficiency. May I proceed? Thank you. Therefore, again as in the same case, again as in the Mr. Abdullah Sanisi Appeals Chamber judgment, even if there is a violation of the right to a fair trial, the OTP has to prove that this provision can no longer be regarded as a genuine form of justice because of the violations of the right to a fair trial. And the fact that Mr. Gravus is being investigated by a military court doesn't meet this high threshold. Your Honors, contrary to what OTP argued, there is no indication that Hanatun is unable to investigate or there is a collapse in an international judicial system. The destabilized situation in the country ended by the coup. There is no civil war, unrest, or other factors that renders judicial proceedings impossible. Therefore, Hanatun is totally able to investigate the matter. Your Honors, unless I have further assistance to this pre-trial chamber, this concludes my submission, and I yield the floor to my co-counsel, Mr. Hemed Venga.
Mr. President, Your Honors, it is a privilege and a responsibility to appear before you today on behalf of the defendant, Mr. Gravus, in a case of singular importance for the court, the rule of law, and for the international community as a whole. My name is Swale Hemed Wengo, and my task today is to conclude the submissions of the defense regarding to the question of superior responsibility as submitted by the Office of the Prosecution. Mr. President, Your Honors, it is our task today, so far as humanly as possible, to stand on the core values of justice. We must never forget that the record on which we judge the accused today is the same record on which history will judge us tomorrow. And therefore, throughout these submissions, we must abide by the core values of criminal justice, that criminal responsibility should only be attributed to an accused person if there is some form of nexus to the crime. Now, the Learned Counsel for the Office of Prosecution first invoked the provisions of Article 28A, classifying Mr. Gravus as a military superior. But it is pertinent for the court to note that the same Office of the Prosecution, when they were talking about the question of jurisdiction, they invoked the specific intent of Mr. Gravus. Now, the requirement under the specific intent is that the perpetrators, the principal perpetrators, must be the ones who have specific intent. And therefore, if they are invoking Mr. Gravus has specific intent as a principal perpetrator, then why didn't they prefer charges under Article 25 of this court statute rather than Article 28, which requires an elaborate mens rea in terms of knowledge, either the superior knows or owing to the circumstances should have known. And therefore, these takes a contradiction between the submission of the prosecution as to the question of jurisdiction and as to the question of criminal responsibility.
Counsel, if I can just stop you there. I take your point, but is it really a contradiction? Because of course, for superior responsibility, the mens rea is a lower standard than it would be under 25(3)A. So the prosecution is saying, well, it's not just that as a superior, he has the knowledge required, but he also goes further and he has the specific intent for the crime of genocide. There are other reasons why they might have charged superior responsibility rather than 25(3)A, which are to do with the nature of the alleged contribution that he makes. Obviously, under Article 28, they're saying it's an omission, it's a failure to prevent or punish. So surely that's the explanation for their position. And it's not such a contradiction as you now suggest that it is.
Well, thank you for the guidance. However, our submission is on the aspect that they rely specifically on the aspect that Mr. Gravus had specific intent. We do not dispute that if they invoke the specific intent of Mr. Gravus. However, we understand that that is one position in terms of the knowledge-based approach. However, there is the purpose-based approach, which has been established and has been accepted by the jurisprudence of the different international courts and tribunals. The ICTY in Bradanin case, the Akayesu case in ICTR, as well as Ruzindana and Kayishema, and the Musema case have all indicated that the principal perpetrators are the ones who are required. If a superior has specific intent, then such a superior should not be charged as a superior, but rather should be charged as a principal perpetrator. And therefore, we submit in the circumstances of this case, they should have preferred charges under that. And indeed, this—
Okay, counsel, just to understand you right, if we disagree with the prosecution that the Mr. Gravus doesn't have genocidal intent, does not possess intent to destroy a group, but can we still find that he's responsible under under Article 28, under superior responsibility?
Well, indeed, we submit that in that situation, then we submit that Mr. Gravus cannot be held criminally responsible under Article 28A. Specifically, in the submission of the oath prosecution, they first invoked that Mr. Gravus had effective command and control. But the jurisprudence of the ICTY, specifically in the Celebici case, notes that effective command and control is the material ability of a superior to either prevent or punish the alleged atrocities being committed by the subordinates. And therefore, in terms of determining whether or not Mr. Gravus, in the circumstances of this case, had the material ability to prevent, it is pertinent to note that this court, in its own jurisprudence, specifically the appeals chamber decision, has noted that it is more difficult to establish that a superior had the material ability to prevent when there exists a distance between where the superior is as well as where the alleged atrocities are committed. And in that sense, by virtue of the geographical distance between where Mr. Gravus is and where Castria is, it is important for the court to note that the material ability to prevent cannot be attributed to Mr. Gravus, because the court has noted that only a superior who is on the ground with the forces is in a position to be able to prevent. And indeed, in the circumstances of this case, Ms. Jolie, pursuant to paragraph 4, is with the forces on the ground. And at the same time, exhibit number 1 goes on to support that position where Ms. Jolie says she is personally observing the situation, and at the same time, where her forces go on to arrest civilians by mistake, she is having those civilians released. A clear indication that Ms. Jolie had the material ability to prevent. And indeed, the office of prosecution refers to the last part of exhibit number 1, where there is an orders that are being issued by Mr. Gravus that Ms. Jolie should report any security concerns, as well as paragraph 11 of the fact sheet. But what this elaborates is that Mr. Gravus had the overall control of the situation. And as noted by the ICTY, specifically the appeals chamber, in the Halilovic case, a superior having overall control is not sufficient. Only a superior having effective control is the requirement for the purpose of holding such a superior responsible. And in the circumstances of this case, Mr. Gravus only had overall control, but not effective control. And to that effect, we submit that Mr. Gravus is not criminally responsible.
Counsel, if I can just clarify one thing. I understand your submission. Are you saying, as a matter of law, that a hierarchically or geographically remote superior can never have the degree of effective control that's required? Or are you saying, just on the facts of this case, that Mr. Gravus did not have the degree of control that was required?
Well, we submit that in the circumstances of this case, there are not sufficient evidence to establish that. We note that other circumstances will be treated otherwise. However, in the circumstances of this case, this geographical distance does not provide for the effective control of Mr. Gravus. Now, regarding to the question of knowledge, first and foremost, the Learned Counsel for the prosecution argues, and in their words, that Mr. Gravus did not take any steps for the purpose of having that knowledge being inferred upon him. And their submission was premised specifically on the aspect of whether or not the information that was available for the international community, the European Union, and the Security Council. And therefore, they argued that it is not possible that the superior did not know. However, this court in the Bemba case has noted that the knowledge of a superior cannot be presumed. And therefore, we cannot make a presumption that Mr. Gravus knew just because the others know. At the same time, that kind of information has been relied on based on the International Human Rights Defenders report. But this report cannot be admissible before this honorable court, as noted pursuant to the provisions of Article 15.1 of this court statute and Article 18.1 of the ICTY statute. Such kind of evidence can only be used for the purpose of initiation of investigation by the Office of Prosecution, but not for the reliance for the purpose of criminal responsibility. And therefore, we submit that in the circumstances of this case, such kind of evidence cannot be used for inferring knowledge on the purpose of Mr. Gravus. Mr. President, I see my time is up. If you may allow me 1 minute to conclude.
If you can make it a little less than 1 minute, that would be great. A couple of sentences.
Thank you. Mr. President and Your Honors, we invite you to reject each and every one of the prosecution submissions for the reasons that we have stipulated before you by myself as well as by my distinguished colleagues. None of the prosecution submissions passed legal scrutiny. Indeed, the submission of the prosecution, they are novel, unprecedented, unsupported by the facts, and they are historically absurd, as well as they are not in comparison with the text and the negotiating history of this court statute, and therefore they must be rejected. Thank you. That concludes our submission as the defense.
Thank you very much. And now we'll turn back to prosecution counsel for the rebuttal. Just before we start, I know, prosecution, that you were dealing with technical issues, and I just wanted to check that you're both okay as you are now.
Yes,
yes, Your Honor.
Brilliant. Thank you very much. Then the floor is yours. You have 5 minutes.
Thank you, Mr. President. Your Honors, may it please the court. The prosecution will now address several errors which the defense made in the course of their pleadings. First, the OTP obviously answered the question of a manifested pattern of the acts, the scale and duration of the acts that my co-counsel described, taken together with the discriminatory politics and hate speech against Castilians, must be considered a manifested pattern. Second, Castilians are indeed a protected group as an ethnical group. The OTP is aware that the term Castilians have two meanings. However, Castilians, the Otati-speaking peoples, constitute the majority of the population in Castilla, it is said in the case facts. And we should also remember about the testimony of Mr. X, who was released only because he was of Hannu ethnicity. Third, the defense seems not to have noticed that the OTP indeed stated that the genocidal intent was shared by both Mr. Gravos and the direct perpetrators of the crimes. Fourth, and which is extremely alarming, the OTP would like to point out that during the defense's argumentation, they did not refer to the numerous attacks of sexual violence, which is one of the key issues in this case. Hence, the prosecution assumes that defense shares the OTP's views on this matter. 5, concerning the issue of admissibility, as the defense rightly pointed, the burden of proof lies on the defense challenging the admissibility. As the court stated in the case against Gbagbo, the initiation of proceedings and the fact that suspect was placed and maintained in detention are not sufficient per se to demonstrate that the case against her is being investigated. Indeed, for the admissibility challenge to succeed, it must be established that tangible, concrete, and progressive investigative steps are being undertaken, yet the defense did not provide any evidence to that. 6, the OTP at no point brought the inability of the military court, contrary to what the defense has stated in their pleadings. 7, the defense did not prove, as well as the vaguely stated scope of the proceedings, indeed includes substantially the same conduct of Mr. Gravos as alleged before this court. Next, regarding impartiality and senior military officials, the independence of the investigation should be assessed also from the practical perspective, meaning that the eventual practical implications are not following suggestions from military superiors. 9, the defense seems not to understand that the OTP's argument concerning the nature of the military court. The prosecution did not indicate at any stage that the sole fact that Mr. Gravos is judged by the military court implies lack of genuine investigation. In our pleading, we point out a number of particular circumstances which the defense seemed to have omitted. Next, there is no conflict between the genocidal intent and mens rea in Article 28A. Superior responsibility is a form of omission liability, and omission can be intentional. The OTP presented its arguments indicating also Mr. Gravos' intent, for instance, his speech. It is obviously possible to charge a superior for genocide, as we saw, for example, in ICTR and Musema judgment. 11, the defense addressed Bemba appeal judgment and then remote command. This judgment was highly controversial. This is indicated, for instance, by the dissenting opinion of Judge Hofmański. The controversies concern mostly the prosecution of sexual violence crimes, which is in the case of the proceedings. Hence, the OTP submits the defense is not aware of the nuances concerning the remote control doctrine, especially in the cases like this one, and that we are in this case in the year 2019. And the superior does not to be geographically present, physically present at the ground of the actions. Next, the defense claimed that the reports of the NGOs are not admissible, which is simply not true. According to Article 54(1)(a) of the statute, the prosecutor shall extend the investigation to cover all facts and evidence relevant to assessment of criminal responsibility. Non-governmental organizations' report may constitute relevant information as recognized in the rules of procedure and evidence. Mr. Gravus indeed have effective control, and it could be established on the basis that his orders were being followed. Lastly, we do not presume Mr. Gravus' knowledge of the crimes. We present circumstantial evidence to prove his knowledge, and this is a huge difference. Your Honors, the prosecution once again invites the court to share the views presented in our pleading and not to take a step back in the prosecution of genocide and especially sexual violence crimes. Unless I can be on your further assistance, this concludes our rebuttal.
Thank you very much, counsel. I don't think there are any further questions from the bench as far as I can see. So on that basis, we'll now move to the rebuttal from the defense. Thank you.
Thank you, Mr. President, Your Honors. We appreciate this opportunity to be able to blow away some of the cobwebs of confusions and deceptions, as well as errors and misconceptions that seems to have willfully befallen the prosecution's case. Now, first, they argued on the issue of manifest pattern of similar conduct. This is a critical element that this court has agreed that it is an element within the jurisprudence of this court, specifically in the arrest warrant decision of Omar al-Bashir. And therefore, if the prosecution wants to negate this specific element that is provided for, not just within that jurisprudence, but also under the element of the crimes, then it is pertinent for the court to note that if they are not able to establish this, then this court cannot go ahead and find that in this aspect genocide was committed. Secondly, the issue of ethnic group. It is pertinent to note that clarification number 1 points out clear that Castrians does not only refer to the ethnic minority group, but also refers to the people in Castria. And therefore, throughout these submissions, the aspect of distinctness of such a group is pertinent. And as noted by the jurisprudence of the ICTY in Jelicic as well as in Kristich, it is important to establish specifically the distinct nature of such a group, because an attack on the whole population does not amount to genocide unless all the population, they are part and parcel of the people who are protected under the Genocide Convention as well as under this court statute. And to that effect, we submit that the distinct nature of the ethnic group in this situation is not made. Thirdly, they talked about the issue of sexual violence. And it is important for the court to note in these circumstances that such acts are not part of the enumerated acts within the confines of Article 6 of this court statute. And therefore, it is pertinent to note that if such an act is regarded to be part of those acts, then unless we are rewriting the Rome statute again in order to include certain acts that do not form part and parcel of the acts enumerated under Article 6. Then the Office of Prosecution went on to talk about the issues of the admissibility of this matter. First, they talk about the issue of independence of the court, and they clearly referred to the jurisprudence of human rights courts in terms of establishing that in this situation, there was shielding because the conduct of the military trial was one that was not proper, because according to them, that in such a situation, it amounts to the lack of independence on such a court. But it is important, the jurisprudence of this court, specifically in the El Senussi decision, has noted that where there is a question of shielding, shielding will only arise if there are obvious and unexplained deficiency in the national investigation, and the perpetrators of such acts they go ahead unpunished. Now, the Office of Prosecution has not provided any evidence to show that the investigation by the military court had any obvious and unexplained deficiency. Their only argument is because it's being charged by military court. However, it is important to note, Mr. Gravers is a military officer, and therefore he can be charged before the court, as well as the act that is being alleged is one that is in regards to international crimes, as noted by the jurisprudence of the Human Rights Committee, that such a situation, such matters can be handled by military courts. Then the learned counsel for the prosecution went on to talk about the intent, specifically the intent of Mr. Gravers within the aspect of knowledge. It is important to note that the standard they are trying to ask this court to apply is the standard applied by the ad hoc tribunal, which is had reason to know. And as stated by the Mucic case, such kind of standard is one that requires where the superior to take action and do a further investigation in order to find out whether or not such an information is true. However, in the circumstance of this case, it is not the required standard. The should have known standard, as explained by this court in the Bemba case, is that the superior must only be negligent to seek for such information. And pursuant to the last exhibit number 1, it is clear that Mr. Greyfus went on to go ahead and seek for such information. Mr. President, Your Honors, the genocide crime evolves from the Genocide Convention, a treaty of singular importance in the modern history of international law, one of the fundamental multilateral treaties of our time. To invoke the 1948 Convention as well as the crime of genocide under the 1998 Rome Statute, it's a matter of utmost gravity. It is not something to be done lightly. And we hope when you retire to make deliberation over this matter, the critical question that will linger in your minds is whether this court will allow the prosecution to invoke the genocide crime very lightly. And the answer to that question lies in the submissions we have made. Thank you. That concludes our SARI battle.
Thank you very much. And unless my colleagues have any further questions, I think that concludes our submissions. Thank you to all of you for your assistance that you've provided so ably. We will now withdraw and deliberate for some minutes, and then we'll return with our verdict as soon as we possibly can. Thank you very much.
Also, congratulations to all the performances I've seen here from my perspective. I shall now put each and every one here in the respective breakout session or the deliberation room. See each other afterwards.
Thank you very much, everyone. I'm not sure if we're waiting for the court clerk or not, so I'll just hang on for 30 seconds. Yeah. Thank you. Mr. Clark, can we proceed or are we still waiting?
We can proceed.
Thank you very much. Well, we have now reached the end of these proceedings and the bench would first like to provide some feedback to the participants, and then we'll go on to tell you our verdict. I'll probably start off providing the feedback, but both my colleagues might well jump in if they have anything to add as we go along. Above all, and before anything else, we'd like to say thank you very much to all of you for providing such great submissions. I know from personal experience that working to provide legal submissions online when you're not in the same room as the judges or as each other is a very particular challenge. In my view, it's much harder than doing it when you're in person and you can see and hear people more directly. So well done to all of you for coping with that so well. And also particularly well done to the prosecution for dealing with the dreadful horrors of technology. What happened to you is absolutely the nightmare scenario for any advocate, and you both dealt with it with a lot of poise. You remained calm, you were very respectful, you were very clear with us, and that was a really great thing. So thank you for that. In general, we thought the standard of your presentations was very high in a problem, and of course, I'm not going to talk about the substance because one of you will be going forward in the competition, but a problem which offers an awfully large number of things to talk about in quite a short space of time. And so that's a real challenge, I think, for all advocates, because on the one hand, you want to make sure you cover all the points that you think might come up. But on the other, you also need to be selective because you only have a certain amount of time. And therefore, there's really a question for you about which points are going to be the most persuasive and most significant for your argument. And that also relates a little bit to the question about pacing and tone. Obviously, if you come into these submissions and you think, right, I've got 50 points I need to make and I've got 25 points to make them, you know, you come in, you're right, okay, off we go, and you launch into it, and it's very fast, and it's a bit overwhelming if you're on the other side of the courtroom trying to understand what the argument is, and really what's the thing that the judges need to be either convinced by or worried about. So again, this question about picking your battles is really important, and I think you all did that, but I think you can all consider doing it a little bit more. Another thing that I really liked was the degree in which some of you made your submissions quite responsive to the things that you'd already heard. And that's great, because again, what we're looking for in these kinds of circumstances really is a respectful and clear legal debate between prosecution and defense, which the judges can then understand the strengths of the different arguments and be persuaded by that. There is a question, though, about sometimes, do you take a point which is a bit too far? Does it really help you to seize on every point that you've heard from somebody else? And this goes back again to picking your battles. Sometimes you might hear something from the other side and you think, I'm not sure I really, agree with that, or I don't really like that, but it doesn't necessarily help you. Or the point is so complicated that it's going to take, 5 minutes of your precious time to explain why you think they were wrong, but actually the benefit that you get is going to be pretty limited. So I think the main comment for everybody is, sometimes less is more. The first part of being an advocate is, okay, can I say the stuff I'm prepared to say? You can all do that. The second part of being an advocate is, okay, and sorry, I just lost you there, but I think you can still hear me? Yeah. So the second part is, how much do I really need? And I know for myself that often, having written my submissions, which might be 10 pages, I then go back and I cross everything out and I'm left with 4 pages at the end of it, because a lot of the time what we think is important may not actually be the killer point. My final very small comment is also just to say, particularly It depends on which forum you're in, whether it's at trial or on appeal, or the kind of bench or which part of the world you practice in. But always be thoughtful about the kind of tone that you strike. Confidence is great. And demonstrating that you have command of the law and command of the facts is the thing that's going to be really persuasive. You don't have to be too assertive in saying that the other side is wrong to demonstrate your confidence that you are right. And so sometimes you can maybe just notch back the argument a bit. We understand, the judges are in the room as well. They've heard what's going on. They know where you're coming from. But again, a little bit less can be a little bit more. And it helps to build the confidence. Also, because sometimes, when the judges talk to you, judges are people too. And they might be worried that, you might give a slightly snippy answer back to them. So again, the more you just err on the side of, I'm the friendly, reliable, confident, helpful person to assist your honours in deciding the case. That's the thing I always find very persuasive. But that's my feedback for you all. Don't take that as a criticism. I thoroughly enjoyed the whole event. I think my fellow judges would agree with that. And we're very grateful for everything you've done. And we wish you the very best in the competition as it goes forward. Unless my colleagues have anything to add, and I'm looking at them and I don't think so, then that brings us to the final point where we will now tell you the outcome of these proceedings. First, in terms of the winner, we can say that we think the defence has won these proceedings. So congratulations to the defence. And now in terms of the best speaker, our view was that the best speaker is the first counsel for the defence. Congratulations. And the second best speaker, yes, but we would all applaud, but silently. And the second best speaker was the second counsel for the prosecution. It was a tough battle. These are very hard decisions, and we can tell you that some of these decisions really were on a knife edge. So for those of you who we didn't give the shout out to, please do not take that as saying in any way that you did a bad job. That was our view because we had to give a view, but if we could have given more plaudits, then we might well have done more plaudits. So thank you all very much. We wish you the best of luck. I hope you have a great day wherever you are, and best of luck in the competition. Thank you.
Thank you for your feedback. We really appreciate for your time and your comments. And for the opposing team also, thank you very much for a brilliant competition.
Thank you, congratulations.
Thank you, everybody.
So the criminal court is now adjourned. Thank you.
And thank you, Mr. Clark, as well. Lovely to see you, Roger, and I hope you have a great day. Hopefully our paths will cross again, but if not in this competition, then sometime soon.
I have another one of these, and then I have a board meeting of a journal later in the day. Then I go for a run, have dinner.
You put me to shame, as always. Have a great day.
Right.